Yes or not? So
Yes,
we have,
sir.
yes, we have to start our second chapter or second topic. And as I shared the screen, I think it is visible to you. The screen is visible to you.
Yes, sir.
Yeah. So the topic two, or you can say chapter two, is about the promotion and the formation of the company. And basically, here we will discuss two things. The first is the formation of the company. Section 3 enables that a company may be formed for lawful purposes. 7% public company, 2% private company, and 1%. But the question is, इनेबल तो कर दिया, हाउ टू फॉर्म द कंपनी, कहाँ जाएं, किसके पास जाना है, what are the document that is needed. Okay, so the first portion is about that. It is visible in the this topic. Second, the formation, the second part, B part, formation of company, section 3, procedure of registration, including online register of a company, effect of certificate of incorporation, and registration of the company. Then, the second thing we will discuss here, we'll discuss about the promotion. Who are the promoter and what is their position, what are the powers of the promoter, and what are their duties. And these things we will discuss in light of the famous classical case that is given here on the 13th number, Irlanger versus New Sombrero Phosphate Company, 1872 78, sorry, 3AC 1218. Okay, so first I'm taking the second portion, okay, about the formation of the company. Now I will share another screen where there is the direct, so that you can read from here also. It's about section 3. First I'm taking section 3. Section 3, uh, yes. Section 3 says, is it visible now?
Yes,
Yeah.
sir.
Yes,
A
sir.
Yes, sir.
Section 3, a company may be formed for any lawful purpose by seven or more person. I'm not going to discuss again and again that what is lawful, what is means the person, okay? Where the company to be formed is public company, two or more person where the company to be formed as a private company, one person where the company is to form as a one person company, and that is also be treated as a private company. Now, here section 3 enables us to form the company. Okay, and you, after reading section 3 and in the preliminary classes the different advantages, you thought to form a company, but the question still remains same. Where you have to go, what are the documents that are needed, what are the procedure that you have to follow, and for that, we have to visit to section 7. I'm now coming to the section 7. You also can, if you have the direct, you can come to the section 7. Yes, please, any of you read section 7, either from the screen or you can read from your, direct that you have with you.
Incorporation of company, there shall be filed with the registrar within whose jurisdiction the registered office of a company is proposed to be situated. The following document
Stop,
and
stop. Request, stop. So the first question answered here, that where we have to go. See, in India we have different states, and in the different states there are the registrar of the companies in different states. Okay, and where we have to file, where we have to go for the registration for the incorporation of the company, जहां पे आप अपनी कंपनी का रजिस्टर्ड ऑफिस बनाना चाहते हो. So suppose you want to establish a company and you want to make the registered office in Noida. तो कहाँ पे जाओगे? यूपी वाले रजिस्ट्रार.
Noida.
हाँ, यूपी वाला जो भी है, जो उसके जुडिक्शन में आता है. और अगर दिल्ली में है तो दिल्ली के नीचे. ठीक है. Simple thing. So we have to go? We have to go to the registrar under whose jurisdiction your proposed office or you want to establish the office of your company. First question is answered. The second that I said, that what are the documents that required. अब वहां पे आप चले भी गए, दिल्ली में आप इस्टेब्लिश करना चाहते हो, तो आप दिल्ली के रजिस्ट्रार के पास भी चले गए. Okay, now read this namely.
The memorandum and articles of the company duly signed by all the subscribers to the memorandum in such manner as may be prescribed.
Stop. Now see, this clause A have three parts. First is about, it is talking about two document. One is memorandum. Memorandum means memorandum of association. Memorandum of association, MOA. And second is articles, that means articles of association. What is memorandum of association? Section 4. I just want to show you that here there is this section 4. Yes, section 4. Is it visible? Memorandum. And if you remember, in our preliminary class, I told you that in a memorandum, there would be 5 things important. The memorandum and article of association are the constitutional document. Constitutional documents means those documents by which the structure of the company is created. Memorandum में क्या होते हैं? First आपका होता है name of the company, A clause में. B में आपका क्या होगा वहां पे? The state in which the registered office of the company is to be situated. The third is object for which you want to form the company. The fourth is the liability. लिमिटेड लाइबिलिटी कंपनी होगी या आपकी अनलिमिटेड लाइबिलिटी कंपनी होगी. अगर लिमिटेड होगी तो शेयर से लिमिटेड होगी या गारंटी से होगी. एंड फिफ्थ वन, अगर शेयर कैपिटल है तो हाउ मच शेयर, एंड इन each portion it is divided so that the value of the share we can find out, and how much share are subscribed by the members. So these 5 important things. There is some special things related to the one person company, but at least you can remember the 5 things that is mentioned in the memorandum of the association. In the articles of the association, there are some daily basis or some other subsidiaries matter are written. Okay, in the detail, that what we will write in the memorandum and what is the relevance of the memorandum, what we will write in the articles of the association. Then there are the formats also provided and attached to the schedules to the Companies Act, that we will discuss when we will discuss the third topic, the company's constitutional document. यानी ये डॉक्यूमेंट आपको प्रिपेयर करने हैं, memorandum of association and articles of association. Second element here is about the that it has to be signed by all the members. Why it has to be signed by all the members? Duly signed by all the subscriber. Why duly signed by all the subscriber? Can anyone want to answer this? See, the partnership हुआ or the company, these are creation through your agreement. They are not created by the status. These are created by the agreement. And so, all person must agree, all the member, all the subscriber must agree to these two documents. Okay, that's why these memorandum and article must be duly signed by all subscriber. जैसे अगर आपके 8 मेंबर है तो 8 से साइन होना चाहिए, 7 से साइन होना चाहिए. बट हाउ दैट होज बी, साइन का कोई फॉर्मेट तो होगा, किसी तरह से कुछ होगा. फॉर दैट द पावर इज गिवन एज मे बी प्रिस्क्राइब. वेन एवर दिस वर्ड इज रिटन एज मे बी प्रिस्क्राइब, इसका मतलब है पावर गवर्नमेंट को दी हुई है. गवर्नमेंट रूल से एक मेथड या कोई बताएगी कि इस तरह से साइन होने चाहिए, तो उसी तरह से साइन होगा. ओके, सो दीज आर द 3 थिंग्स फॉर in the clause 1. So with when we approach to the office, we must have two document, memorandum and articles, and these document must be signed by all the subscriber here means who subscribe these memorandum, so you can say all the members of the company. Okay, then read clause B.
A declaration in the prescribed form by an advocate, a chartered accountant, cost accountant, or company secretary in practice who is engaged in the formation of the company, and by a person named in the articles as a director, manager, or secretary of the company, that all the requirements of this act and the rules made thereunder in respect of registration and matters precedent or incidental thereto have been
Yeah,
complied
thank
with.
complied, thank you. Now after these two documents there must be a declaration. Declaration किस चीज की? That all the rules, regulations or the provision of this act are duly complied. Okay, and this declaration form किससे साइन होना चाहिए? एडवोकेट, एक चार्टर्ड अकाउंटेंट, एक कॉस्ट अकाउंटेंट और कंपनी, बाय एन अकाउंट एडवोकेट, चार्टर्ड अकाउंटेंट, कॉस्ट अकाउंटेंट अथवा कंपनी सेक्रेटरी इन प्रैक्टिस, any of them can sign that declaration. This declaration is only with respect to that in the, you know, during the formation of this company or whatever written here, the person named in the articles, director, member, all these requirements is with respect to the companies act or the rules framed under the companies act. Okay, now comes the question that what happened if the person like the advocate और द चार्टेंट अकाउंटेंट, और ये एडवोकेट एंड चार्टेंट अकाउंटेंट आप कोई बाहर से नहीं ले सकते, वही जो इस पूरे प्रोसेस को फॉलो किया हो. ओके, a declaration in prescribed form by an advocate, chartered accountant, cost accountant or company secretary in practice who is engaged in the formation of the company. Okay, because the person who is not engaged in the practice or who is not engaged in the formation of the company may not be aware about all the facts. Okay, now what would be the consequence if the declaration has been given but still there is the, you know, the problem, or you can say that the rule has not been complied or there is the violation of any provision? For that the consequence is in 7 clause 5. Okay, I'm not going to discuss here, all these clauses C, D, E, F we will discuss, and the consequence of those clauses are in 7 clause 5, so there we will discuss, at once. Read clause C. तो फर्स्ट आपका मेमोरेंडम और आर्टिकल हो गया, सेकंड आपकी डेक्लेरेशन हो गई, थर्ड सी, क्लोज सी, प्लीज रीड क्लोज सी.
So the clause C which is in the screen is different and which I have is it is different.
Okay, no need, you read from whatever you have with you. A
A
declaration.
declaration
Hmm.
a declaration
Earlier there was this word affidavit. Now with the affidavit, the word has been substituted as a declaration. This is old act. Okay.
okay sir.
Yeah. A
A
declaration.
declaration from each of the subscribers to the memorandum and from persons named as the first directors, if any in the articles, that he is not convicted of any offence in connection with the promotion, formation or management of any company, or that he has not been found guilty of any fraud or misfeasance or any breach of duty to any company under this act or any previous company law during during the preceding 5 years, and that all the documents filed with the registrar for registration of the company contain information that is correct and complete and true to the best of his knowledge and belief.
Yeah. So see, आपकी कंपनी रजिस्ट्रेशन के बाद में बनेगी. By virtue of section 9, your company will be a separate legal person. So the company will born from the date on which the certificate of incorporation or that is mentioned in the certificate of incorporation. Maybe डेट 23 की मेंशन हो, सर्टिफिकेट आपको 27 को मिल रहे हो, तो लीगली 23 को ही योर कंपनी हैज बीन टेकन बर्थ. ओके, बट company in the law is a recognized separate person, but company does not have mind, company does not have body. So how it will work? Company will work through the natural person, and these persons are known as directors, who see or look after the affairs of the company, and these persons do the work. And in the law we presume that these work, or we attribute the work of director to the company to the certain extent. Okay, now the first director, the name has to be given. After that the director will be elected. But when the company will take birth, suddenly it has to do certain things, and for that directors are required. Okay, and it is for public company minimum 3 director, for private company minimum 2 director, and for one person company why 1 director. So the name of the directors or directors you have to be select. And with respect to these directors, the declaration has to be submitted. In clause C, a declaration has to be submitted with regard to the director's antecedent, that in the past they have not committed any offense related to promotion of the company, the offense that have some connection with the companies, or has not been convicted, etc., in the last preceding 5 years. So, in the nutshell, you can say the declaration regarding the director's antecedent. Here again, the question comes that if the person knowing that director has been convicted, but he said in the declaration that no director has been convicted in last 5 years. So, what would be the consequence? Who will be responsible? What will be the fate of the company? Two question arises, that who will be responsible? कंपनी तो नहीं हो सकती, बिकॉज कंपनी तो बेचारी पैदा भी नहीं हुई. एंड द सेकेंड इज व्हाट विल बी द फेट ऑफ द कंपनी. कंपनी का क्या कंसिक्वेंस होगा? कंपनी रजिस्टर्ड हो गई, लेकिन उसमें डेक्लेरेशन फॉल्स थी, और डायरेक्टर का जो पास्ट एंटीसीडेंट था वो अच्छा नहीं था. सो दैट वी विल डिस्कस सेक्शन 757677. ओके, नाउ रीड क्लोज डी.
The address for correspondence till its registered office is established.
Yes. When the company will be duly incorporated, then the office, the address you have given in the memorandum of association will be then the official or registered office. But before that, suppose before that you have filed the document and the registrar of the company want to communicate with you, भाई आपके फॉर्म में तो ये गलतियां थी, अभी आपको नहीं दे रहे सर्टिफिकेट ऑफ इनकॉर्पोरेशन, तो वो कहाँ पे आपसे जो है पत्राचार करे? सो द एड्रेस फॉर द कोरस्पोंडेंस, and this address for the correspondence is not that official address. प्लेस सेम हो सकता है, आपने पहले प्लॉट लेके गिर रखा, वहीं से आपने दे दिया, वो अलग बात है. But the address of the correspondence till the office is established. So the purpose of this address is only till the office is established. When the registered office will be established, then that would be the the address of the company. Okay. Yes, clause E.
The particulars of name, including surname or family name, residential address, nationality, and such other particulars of every subscriber to the memorandum, along with proof of identity, as may be prescribed, and in the case of subscriber being a company, such particulars as may be prescribed.
Yeah. So clause E is basically dealing both. Suppose your members are the natural person. You 7 persons, you 7 students from the law faculty want to establish the company, because you all are major, you can do. So when you will go for formation of the company, as per the clause E, आप सबके नाम, आपका एड्रेस, आपका रेजिडेंशियल एड्रेस, आपकी नेशनैलिटी और भी कुछ पर्टिकुलर्स जो फॉर्म में यहाँ पे नहीं लिखा है, बट इट मे बी थ्रू द रूल्स as may be prescribed. That mean as may be prescribed, whenever this word is written as may be prescribed, that mean the power will is given to the central government, and central government through the delegated legislation will follow the rules, और उस रूल्स में जो जो डिटेल और भी लिखी होंगी वो भी आपको देनी है। एंड विद द आइडेंटिटी प्रूफ, जो आपका आधार कार्ड या जो भी वैलिड आइडेंटिटी प्रूफ के साथ ये सारे डॉक्यूमेंट, देखो कितना लेंदी हो जाता है। सो दैट थिंग इज डन। The second situation is, suppose you six are natural person and one is company, or five are natural, two are the company. So in case the subscriber is the body corporate, so the particulars of that company is also be given. अब उस particulars में क्या क्या बताने हैं वो, that detail is not provided here. Through the rules you can find out the details also. Okay. Yes. Now again there is same question, that if any person you know has provided the false information, नाम आपका श्याम सुंदर है, नकली आधार कार्ड के साथ आपने फार्म भर के कंपनी फॉर्म कर रहे हो, what would be the consequence? So these are not the something that in the air I'm telling, it happens, होता है ऐसा। So in that case who will be responsible, what would be the fate of the company, etc. Now read clause F.
The particulars of the persons mentioned in the articles as first directors of the company, their names, including surnames or family names, the director identification number, residential address, nationality, and such other particulars, including proof of identity as may be prescribed, and
Yeah, thank you. So in the next clause, in the clause F, the directors, for the directors, you have given the declaration in clause C that they have the good antecedent. Here, you have to give the name of the director, their address, and other details as may be prescribed. And every director and the person who want to be the director have to taken a particular number that is known as the director identification number, DIN. And the purpose of the director identification number is that it is unique. It has given to only one person, to one person once. Okay, you cannot take two director identification number. The purpose is, earlier, many influential persons were used to be director in several companies. Then it was found that these business enterprises has to work, and the directors are actually the brain of the company. And when they are not able to perform the function, then what is the purpose they are serving? And so a cap was put that for a director he must be in 20 companies, at most in 20 companies. So by director identification number, two purposes are served. One, the particular of that person will be confirmed. The second is, it would be confirmed कि पहले वो कितनी कंपनीज में डायरेक्टर रहा हुआ है। सो दिस क्लोज ऐप में जो डायरेक्टर आइडेंटिफिकेशन है वो दो पर्पज आपका सर्व कर देता है। एंड विद दैट सम अदर जैसे जो आपका पर्टिकुलर्स है वो भी आप इसमें मेंशन करना है, लाइक नेशनैलिटी, प्रूफ ऑफ आइडेंटिटी, एटसेट्रा एटसेट्रा। ओके, यस अभिषेक, आस्क द क्वेश्चन।
सर ये जो इसमें डायरेक्टर है, डायरेक्टर तो नेचुरल पर्सन ही होगा ना। डायरेक्टर ज्यूरिस्टिक पर्सन तो मतलब कोई एक कंपनी दूसरी कंपनी की डायरेक्टर तो नहीं बन सकती है ना।
हाँ, तो इसमें कहाँ लिखा हुआ कंपनी वाला? वो सब्सक्राइबर में है कंपनी वाला, यहाँ पे नहीं लिखा हुआ ना कहीं पे।
मतलब
यहाँ
डायरेक्टर
पे
सर
तो
नेचुरल पर्सन ही होगा।
नेचुरल, ऑलवेज, always
सर
be
यहाँ पे
natural. And that's why
सर
you can differentiate between the language of clause E and F. E में उनको इस तरह से फॉर्मुलेट किया गया है कि when the natural person and when the subscriber are body corporate, यहाँ पे इस तरह का कोई आपको डिफरेंस नहीं मिल रहा होगा।
जी सर।
यस।
सर और इन्होंने सर यहाँ पे नेशनैलिटी की बात की है, सिटीजनशिप की कोई बात नहीं की है इन्होंने।
सिटीजनशिप और नेशनलिटी, अगर उस हिसाब से आप देखो,
क्योंकि सर सिटीजनशिप तो लोग रिनाउंस कर देते हैं।
बेसिकली उससे कुछ ज्यादा फर्क नहीं पड़ता. इट इज जस्ट ओनली टू यू कैन से डिटरमाइन दैट हु इज एक्चुअली दैट पर्सन, ओनली दैट पर्पज. नेशनलिटी हो नहीं भी दूसरे की भी होगी तो कुछ फर्क ज्यादा नहीं पड़ रहा है यहाँ पे. तो यहाँ सिटीजनशिप का मतलब नहीं है. सिटीजनशिप एक अदर कॉन्सेप्ट है, नेशनलिटी एक डिफरेंट अलग कॉन्सेप्ट है. समझ रहे हो ना आप? सो नेशनलिटी के ऊपर ही ये डिफाइन होगा कि आप उसके नेशन नेशनलिटी आपके पास है या नहीं है, वही आपको बताना. लाइक वी सो द इंडियन इनकम टैक्स में एक अलग टर्मिनोलॉजी होती है, वहाँ पे 182 लोगों का होता है. एंड सिमिलरली इफ यू गो थ्रू द रूल्स इन वन पर्सन कंपनी में भी नेचुरल पर्सन के साथ वो 182 डेज इंडिया में रेजिडेंस करना चाहिए, ऐसा मैंने पढ़ा है. Okay, but I'm not going in that much of the detail here. Nationality have to be given, citizenship you have not to give that you have not to mention. Nationality you have to mention. Okay.
जी सर, थैंक यू सर।
Okay, then in the last clause, please read clause G.
The particulars of the interest of the persons mentioned in the articles as the first directors of the company in other firms or bodies corporate, along with their consent to act as directors of the company in such form and manner as may be prescribed.
Yeah, the particular of the interest of the person mentioned in the article as the first director of the company or other form or body corporate along with their consent to act as a director of the company. Yeah. यहाँ पे in this clause G, it has also been mentioned that the direct, the person, the particular of the interest, these director have, okay, in the other firm or the body corporate, that also has to mention कि वो दूसरी कंपनी के साथ कितना किसमें क्या क्या उसका जो है इंटरेस्ट है, कितनी हिस्सेदारी है, इस तरह की चीज़ें. Just to this particular clause is also has its importance when there is any question that may arise in the future with respect to the conduct of the director. So for that it is also important. And here again important, if one director disclose the wrong statement that he has not interest in a particular company, but actually he has the interest at the time of the this signing of this document or at the time this document has been filed. So for all this type of the misinformation, we have to read section 7 clause 5. Yes, please read section 7 clause 5.
If any person furnishes any false or incorrect particulars of any information or suppresses any material information of which he is aware in any of the documents filed with the registrar in relation to the registration of a company, he shall be liable for actions under section 447.
Yeah. Now see in the section 7 clause subsection 5, it has the sweep over all the preceding subsections. The word used here is that in relation to the any of the document filed with the registrar in relation to the registration of the company. So it would be applicable to clause C, D, E, F, to all, to any document is talking about. Now the second thing is that it has two terms or two phrases. One is about the misinformation or furnish false information. So false information, we understand that if your name is Pramjit and you are writing that Pram Singh, so it is false information. Or your age is 32, you are writing 35, it is false statement. The second is suppression. Suppression of the fact means that you are bound to disclose but you are not disclosing. ओके, आपको लिखना था उसके बाद में uh, suppose there is something that you have to even disclose the interest, but you have not disclosed because, or you have disclosed the interest in two companies but have not disclosed the third one, because the third one, or disclosing that this third fact may be prejudicial to you. Okay, and so this is known as suppressing of the fact. Suppressing of the fact means those fact that you are bound to, or you are aware but you are not disclosing. Even if you are aware, but you are not bound to कि आपकी पास्ट में क्या गर्लफ्रेंड रही है, आपकी शादी कितनी बार टूटी है, अब ये थोड़ी लिखना है. But anything that you are bound to disclose there but you are not doing, so that would not be false statement. झूठ तो आपने बोला नहीं, कोई false statement तो नहीं दी, but you actually suppressed that fact. Okay, have you understood this false statement and suppressing fact?
Yes, sir.
Now the
Yes, sir.
liability is section 447. Earlier also we got the opportunity of 447. huh? Section 447 says that the liability of the act of the fraud, वहां पहले भी हम लोग थोड़ा सा उसमें कंफ्यूज रहे कि फ्रॉड का मतलब फ्रॉड ही होगा. And then the liability, if the company have this much of the threshold, then this liability, or and lesser than this threshold, then the another liability. So that you read yourself section 447. I'm not going to read here, but one thing, that after section 447 there is the explanation attached to it, and in the explanation it is written that the fraud in relation to affairs of the company or body corporate includes any act, omission, concealment of any fact, abuse of the position committed by any person or any other person with convenience in any manner with intent to deceive or gain undue advantage from or to injure the interest of the company or its shareholder or its creditor or any other person, whether or not there is any wrongful gain or wrongful loss. So whether or not there is any wrongful gain or wrongful loss is written. And so here this definition is very broad, that can include any type of the act or omission, etc. Okay, and then this section 7 clause 5 saying that shall be liable for the action under section 447. So the liability is there because the word fraud has been defined in such a broad the term broad manner. Like Hindu marriage act we study, and Hindu means Hindu, but there Hindu means Hindu include Jain, Bodh and Sikh. And so all provision of Hindu marriage act are applicable to these. Are you getting my point? And so in this fraud in section 447, these activity will fall. Okay, so that is about the liability. So liability is about, if any person furnish, then he shall be liable. So liability is to the person who is giving the false statement. If he is the director giving the false statement, he will be liable. If he is the members giving the false statement, he will be liable. If the your chartered accountant or your advocate giving the false declaration, he will be liable. Then the second is about section 7 clause 6. Please read section 7 clause 6.
Without prejudice to the provisions of subsection 5, where at any time after the incorporation of a company it is proved that the company has been got incorporated by furnishing any false or incorrect information or representation, or by suppressing any material fact or information in any of the documents or declaration filed or made for incorporating such company, or by any fraudulent actions, the promoters, the persons named as the first directors of the company, and the persons making declaration under clause B of subsection 1 shall each be liable for action under section 447.
Yeah. So here the clause 5 is making responsible only to the person who is making that statement. And section 7 clause 6 is also making responsible to the promoters, to the directors, even if the statement is by the other person, they will also be responsible. And that's why, without prejudice to the provision of subsection 5 is written. That means if it is that one director has given the wrong statement, one director have suppressed the fact, then he will be responsible in his individual capacity under section 7 clause 5, and the members, the promoters will be responsible as per the section 7 clause 6 also. And this type of extended liability to the promoters and members is to just that they also have, because they have the responsibility, they have the rights to uh, you know look after all the matters should be in conformity with the Companies Act rule and regulations. No fraud has been committed or misinformation has been given in the process of the formation, so they are also liable. Now the question is that company has been incorporated. Section 7 clause is 6 is saying, या कंपनी नहीं इनकॉर्पोरेट हुई तब तो यह है उसी समय रोक देंगे कि ठीक करो, एंड लाइबिलिटी वो हो ही गई आपकी. बट व्हाट इफ द कंपनी हैज बीन इनकॉर्पोरेटेड? यू एज पर द सेक्शन 7 क्लोज 5 वो इंडिविजुअल भी रिस्पॉन्सिबल होगा. एज पर द सेक्शन 7 क्लोज 6 द अदर्स लाइक द मेंबर्स एंड प्रोमोटर भी रिस्पॉन्सिबल होंगे. बट व्हाट वुड बी द फेट ऑफ द कंपनी? what would be the fate of company? Like Hindu marriage act में हम पढ़ते हैं ना, that child marriage is restrained. Okay, but what is the effect of child marriage? Whether the child marriage will be valid or voidable or void. So these are the different things that we discussed there. Yes, Babita?
सर फेट ऑफ द कंपनी होगा कि वो कंपनी मानी जाएगी, मतलब पॉजिटिव ही रहेगा.
वो तो देखते हैं, अभी लॉ पढ़ते हैं, अभी तो हम लोग नहीं पढ़ा है. फैमिली लॉ तो आप लोगों ने पढ़ा होगा. So suppose there is a child marriage, the age of the boy is 20, age of the girl is also 20, and they got married because they have the love affairs. So whether this marriage will be valid, voidable or void?
सर एचएमए के हिसाब से, एचएमए 1955 के हिसाब से ना वॉइड होगी ना वॉइडेबल होगी.
हाँ तो सीधा वैलिड कह दो ना, इसे कितना क्यों घुमा रहे हो?
सर जो उसमें लिखा हुआ था केस में वो सर बता रहा हूँ कि जजेस ने ये नहीं लिखा था कि हम इसे वैलिड कर रहे हैं. उन्होंने सर बहुत एक एस्केप किया था सर वहां से. उन्होंने लिख दिया था इट विल बी नीदर वॉइड नॉर वॉइडेबल. हालांकि
यस.
सर हालांकि सर उन्होंने बाद में उस एक एक्ट और प्रोहिबिशन ऑफ चाइल्ड मैरिज एक्ट में उन्होंने कहा था कि जो माइनर है, मान लीजिए अगर दोनों पार्टीज माइनर है तो दोनों को ऑप्शन मिलेगा उसको रेपुडिएट करने का. अगर दोनों में से कोई एक माइनर है तो उसके एंड पे वो वॉइडेबल होगी,
voidable होगी, बट वैसे परफेक्टली वैलिड है.
सर लिख
ओके.
सकते हैं हम लोग वैलिड क्या सर, क्योंकि
यस.
अच्छा सर क्योंकि हम लोगों ने सर
As per the Hindu Marriage Act, it's perfectly valid because the validity has not been, discarded by any provision. Yes, it is restricted. There is the punishment also, it is prohibited. Then under the Restraint of Child Marriage Act 2006, it is voidable, as you said, as per the option of the party who is the minor, and in some cases void also, when the child is procured, forcefully शादी करवा दी, किडनैपिंग के साथ शादी करवा दी, etc etc. Why under section Hindu Marriage Act 1955 it has not been declared as void, etc.? Because in our rural villages, still there are many marriages who are happened not following this condition of 18 and 21, this binary. So if you declare or if you make such type of the provisions like void, then most of the marriage would be void. कितने सारे बच्चे जो है वो their status would be you know, different. And that's why just, this position is there. Yes.
सर फिर जजेस ने एक डिसीजन में, सर मुझे नाम याद नहीं है, लेकिन सर उन्होंने कुछ खुल के उसको वैलिड वैलिड नहीं बोला कि हम लोग इसको वैलिड करार देते हैं, उन्होंने ये बोला ना ही वॉइड होगी ना ही वॉइडेबल होगी। सर
you
ऐसा
know
क्यों फिर?
the position is that law is not clear, directly not saying that it is valid or not, etc. But when a particular act is not declared as void or voidable, then that means it is valid. Okay, that's why they use this term. Because Hindu Marriage Act 1955 only restrict this type of the marriage, make these the punishable offense, but has not declared that they are, voidable or the void. But after this child marriage, or this Restraint of Child Marriage Act 2006, that is a secular law applicable Hindus to as well as to the Muslims. So वहां पे अब वो हिंदू वाला 1955 वाला कॉन्सेप्ट चेंज होके यू कैन से द वॉइडेबल. Okay, so both things you have to tell, if because we are academic person, but if you in one say, you can say that after 2006 it is voidable. Okay, like when I was serving in the Haryana, first time I come to know, because I was of the view that only dowry is only in the Hindu. And then in the Mewat region, I found that there are so many cases in the Muslim community of the 498A cruelty. And I asked to one person that ये तो डोरी तो हिंदू में होता है, मुस्लिम में कहाँ डोरी होता है और फिर ये क्रूअल्टी, बट बिकॉज दैट इज द सेकुलर लॉ एंड सो इट इज एप्लीकेबल टू एवरी कम्युनिटी. ओके ओके, चलो ये छोड़ो. नाउ कम टू द आवर सेक्शन 7 क्लॉज 7. प्लीज खत्म करना, अभी 5 मिनट हमारे पास हैं बस.
Without prejudice to the provisions of subsection 6, where a company has been got incorporated by furnishing any false or incorrect information or representation, or by suppressing any material fact or information in any of the documents or declaration filed or made for incorporating such company, or by any fraudulent action, the tribunal may, on an application made to it, on being satisfied that the situation so warrants,
Yes, read.
pass such orders as it may think fit for regulations of the management of the company, including changes, if any, in its memorandum and articles in public interest or in the interest of the company and its members and creditors. Direct that liability of the members shall be unlimited. Direct removal of the name of the company from the register of companies. Pass an order for the winding up of the company. Pass such orders, pass such other orders as it may deem fit, provided that before making any order under this subsection, the company shall be given a reasonable opportunity of being heard in the matter. The tribunal shall take into consideration the transactions entered into by the company, including the obligations, if any, contracted or payment of any liability.
Yeah. So see, it's very difficult to answer these questions, as the Babita on the just said that वो perfectly valid होगी. No, in that case, when the case will be filed before the tribunal, what would be this tribunal? CLAT, Company Law Appellate Tribunal. And Company Law Appellate Tribunal has to decide. But Company Law Appellate Tribunal is not a court. That means the Civil Procedure Code would not be applicable. Any quasi judicial body where the CPC is not applicable has to follow the principle of natural justice, PNJ. So जो proviso में दिया हुआ है ना, will give the reasonable hearing, or will the even hear the company. That means he will provide the principle of the natural justice, the reasonable opportunity of being heard. Then the second consideration would be taken, that is mentioned in the proviso, that if the company have entered into some agreement with the other person, company A entered in the agreement with the B, so अब यहाँ पे इसके फेट जो डिसाइड करना है would also affect the B also, because इनका जो agreement है वो fulfillment होगा कि नहीं होगा. So the proviso is taking that thing also be taken into the consideration, and then the tribunal can pass five type of, or can take any decision or pass five type of the order. First is the order as it may think fit for the regulation of the management of the company, including the changes. जो जिस बंदे का नाम गलत है उसको निकाल दिया, this type of the changes they can do, or any other type of the changes they can do. Second is direct that the liability of the member shall be unliability. So यहाँ पे जो है मेंबर्स जो लिमिटेड लाइबिलिटी कंपनी हुए वहाँ पे उनकी लाइबिलिटी अनलिमिटेड हो गई, तो बाद में जाके अगर उनको लगता है तो वो शायद खुद ही उसको बाउंड अप कर देंगे, तब तक तो वो देखते हैं कि कंपनी कैसे चलती है. थर्ड इज डायरेक्ट द रिमूवल ऑफ द नेम ऑफ द कंपनी फ्रॉम द रजिस्ट्रार ऑफ द कंपनी. दैट मीन उसका नेम ही कंपनी से हटा देंगे, एंड दैट वुड नॉट बी. प्लीज स्विच ऑफ योर माइक नवीन. नवीन,
ये मुंह फिर के अंकल जी
मिस्टर नवीन, प्लीज स्विच ऑफ योर माइक.
किलो 1 किलो कर दो.
बताओ. Yes,
Sir, you can also mute the mic.
yes, I'm trying. Is it here now? Can you hear Naveen or not? I have muted, but still the voice is coming. Okay. Then the third is maybe order for wound up, or pass an order for winding of the company, or may pass any other order also. Okay. So these are the action uh, that can be taken by the tribunal, or that order can be passed by the tribunal. Okay. Now come to the the next step, that all the documents one has filed, memorandum articles duly signed, declaration of the antecedent of the the directors, the declaration by an advocate, CA, or chartered accountant. Okay. And the address of the correspondence, and exactly, or particulars of the subscriber, particulars of the director, particulars of the interest of the person mentioned in the articles. These documents were filed, all documents were in the order, all documents were properly as per the order also. Then what the registrar will do? After this, the registrar will take the decision. And section 7 clause 2 is about that what the registrar will do. Please read section 7 clause 2. The registrar,
Sir,
section 7,
sections.
7 clause 2.
The registrar, on the basis of documents and information filed under subsection 1, shall register all the documents and information referred to in that subsection in the register and issue a certificate of incorporation in the prescribed form to the effect that the proposed company is incorporated under this act.
Yes. So after filing these documents, the registrar, on basis of these documents, first he will register all these documents into his register, and then will issue the certificate of incorporation. And section 9 says that in that certificate of incorporation some particulars will be written, and at one place it would be written the date on which it is incorporated. So the date that is written there, from that date the company will be the separate legal personality body. Corporate can possess the property, can sell the property, can possess the tangible, intangible, movable, immovable property, may sue or be sued. Then read section 7 clause 3.
From the date mentioned in the certificate of incorporation issued under subsection 2, the registrar shall allot to the company a corporate identity number, which shall be a distinct identity for the company and which shall also be included in the certificate.
Yes. Certificate के साथ एक corporate identity will be issued. Like, we all have the Aadhaar card. In the Aadhaar card, there is a number, unique number is there. Okay. The purpose of that number, by that number, you can find out the detailed, or the government authority to which this number is filed can find out the detail. So this corporate identity, like, registration आपकी कार का होता है तो एक नंबर इश्यू होता है ना, DL1CAD822224. सो सिमिलर टाइप एक कॉर्पोरेट आइडेंटिटी होगी, और वो कॉर्पोरेट आइडेंटिटी भी आप सर्टिफिकेट में अटैच करके आपको रखना है. अब इस सर्टिफिकेट को करना क्या है आपको, सेक्शन 7 क्लॉज 4.
The
7.5.
company shall maintain The company shall maintain and preserve at its registered office copies of all documents and information as originally filed under subsection 1 till its dissolution under this act.
सो जो कंपनी का जो रजिस्टर्ड ऑफिस होगा, वहाँ पे ये सारे डॉक्यूमेंट्स और ये सर्टिफिकेट भी आपको लगा देनी है. ओके, and this is with the purpose, like whenever there is a question, whenever someone want to see or the question about that the company is duly formed or no, that document can be verified. So all these documents, all the company shall maintain and preserve its register office copies of all documents and information as originally filed under subsection 1. Okay, so this is about the formation of the company. Now in the next class we will discuss about the promoters. Who are the promoters, what are their powers, what are their functions, and what is the position of promoters vis-a-vis the company, and that is in light of the case Erlanger versus New Sombrero Phosphate Company Limited. Have you understood this whole process of the formation?
Hello.
Only 3 sections you have to discuss, section 3, section 7 and section 9. Okay?
हेलो सर.
Yes.
सर माइनर क्या डायरेक्टर वगैरह बन सकता है कंपनी का, मतलब उसमें क्या एज रिस्ट्रिक्शन है?
See, in the inception I said the clause A, section 7(1)(a) talking about that it has to be signed by all the subscriber. So all the subscriber sign के टाइम पे मैंने बताया है कि this is something created through the contract, and under the contract section 10, what say section 10 says that an agreement would be contract if 5 things is satisfied: free consent, competent to make contract, lawful consideration, lawful object, and not expressly declared void. Okay, and who is competent to contract? सेक्शन 12, जो अनसाउंड माइंड ना हो और जो एज ऑफ मेजोरिटी से मेजर हो. तो डायरेक्टर कैन नॉट बी माइनर. Have you got transfer? And this is not only to the company, any other of things that is created through the contract, the minor would not become the full-fledged. Even under the partnership act, minor cannot be the partner, but minor can be inducted as per the section 30. He will become the partner when he got the majority. Are you getting this point? तो ये तो गोल्डन प्रिंसिपल है. जो भी रिलेशन आपका कॉन्ट्रैक्ट के थ्रू हो रहा है, एग्रीमेंट के थ्रू हो रहा है, वहां पे माइनर नहीं इंटर कर सकता. ओके, इट इज नॉट थ्रू स्टेटस, प्रॉपर्टी वाला नहीं है ये. आर यू गेटिंग माई पॉइंट? आदर्श, माइनर नहीं हो सकता. ठीक है. Okay, so guys, with this, today class is over, and rest we will discuss in the next class.
Thank you, sir.
Thank you, sir.